Time of the gentlewoman has expired. The chair recognizes the gentleman from Idaho, Mr. Labrador, for 5 minutes.
Thank you. Good morning. I've actually really enjoyed your presentation and your answers. I like your forthrightness, and I have enjoyed listening to you.
Sure, I'll have to get over this as I go on.
You will eventually. You said you still have 9 years to go. So, as Deputy Attorney General under the Bush administration, you refused to reauthorize the warrantless wiretapping program, which I actually commend you. I think that was a courageous move on your part. You stated that you were asked to be part of something that is fundamentally wrong. My question is, was it fundamentally wrong because it wasn't authorized by Congress, or was it fundamentally wrong because it was not constitutional?
That situation involved programs, and I'm still going to be careful about it because I don't know what part of it's been declassified, where I concluded there was not an adequate legal basis under the Constitution or under a statute or some other legal basis for continuing it.
So in that occasion, did you have a problem with the Constitution, even if it would have been authorized by Congress? Because I understand the Bush administration later sought authority from Congress, because, and I think mostly in part because of your statements. If it would have been authorized by Congress, do you still think that it would have been constitutional, or was it just the legal authority that you were looking for?
I'm searching back in my memory now. It was, and I'm not sure I can remember well enough to answer because there were different angles, different varieties to the issue. And my concern was obviously I'm someone, as you all are, who devoted my life to the rule of law, and there had to be an adequate legal basis for something either in the Constitution or in a statute by Congress. If Congress had acted and the congressional action had not been challenged on a constitutional basis or overturned, I think that would have been an adequate footing.
Okay. Now, severe abuses of this program have actually come to light, including NSA analysts listening to the overseas calls of U.S. soldiers to their girlfriends and wives in the States. But when the wiretapping was challenged, the Solicitor General promised the Supreme Court that if any of the info was ever used in a court, the defendant would be notified. But last year, a Reuters report found that DOJ officials are using NSA-gathered intelligence as leads for criminal cases, without informing the defendant of the origin of the case and misleading federal prosecutors about its origins. Do you believe that such use of NSA intercepts are lawful?
That's a complicated question, one I'm trying to parse to make sure I don't talk about anything that's classified in an open setting. I think the way, I can speak for the FBI, I think the way in which we interact with information collected by the NSA or by the FBI is entirely lawful. And I also understand, I don't know the history you're talking about well enough to comment, but that it is now the practice where someone is notified in the circumstances you talked about.
Okay. Well, the reports are that they were supposed to be notified, and in some cases they have not been notified. And would you investigate any of these allegations if it's true that some of these people were not notified?
I don't know whether it would be FBI jurisdiction to investigate it. I suspect there's an Inspector General who would have jurisdiction to investigate it. That's probably the most I can say based on what I know from your question.
Okay. Maybe we should have a conversation about this. I think this is an area of concern that some of us have about the NSA. I think there's been some abuses, and obviously we're all concerned about Fourth Amendment protections, and from your testimony, it sounds like you are as well. So hopefully we can work together on this. And I actually have no more questions, so I'll yield back the balance of my time.